Jasmine Crockett stepped into the Supreme Court expecting fierce resistance and cold silence. She didn't raise her voice or attack a single justice. But within minutes, her calm argument cornered the bench, forced Chief Justice Roberts to break protocol, and turned a routine hearing into one of the most shocking courtroom moments the legal world had seen in years. Inside the marble courtroom of the United States Supreme Court in Washington, D.C., the air felt unusually heavy that morning. This wasn't a ceremonial session or a routine legal formality. It was a high-stakes constitutional hearing focused on one of the most explosive questions in modern America: whether massive education funding gaps violate equal protection under the law. The tension was already rising, because everyone in the room knew this case could reshape how states fund public schools, and it placed the court directly between state power and children's rights. From the first minute, it was clear this wouldn't be a normal argument. It was going to be a confrontation. Crockett didn't rush to the podium. She walked with steady steps, shoulders relaxed, eyes focused, the kind of posture that tells everyone watching that she wasn't there to perform. Around her, the courtroom carried its usual tension. Some justices sat back with folded arms. Others held pens ready, already prepared to challenge every sentence. Crockett didn't rush to the podium. She walked with steady steps, shoulders relaxed, eyes focused, the kind of posture that tells everyone watching that she wasn't there to perform. She started with the foundation of her argument: equal protection under the law. She walked the court through how education has been treated across decades of constitutional rulings, explaining how earlier cases built the legal framework that still governs public schools today. Then, she did something most advocates avoid. Instead of skipping the weak spots, she addressed them head-on. She acknowledged San Antonio versus Rodriguez, the case often used to argue that education is not a fundamental constitutional right. For a brief moment, a few justices lifted their heads, clearly expecting her argument to stall there. But Crockett didn't hesitate. She explained the limits of that ruling, pointing out what the court said then, and what it never said. She made it clear she wasn't pretending inconvenient precedent didn't exist. She was using it to build a stronger case. As she connected older rulings to modern realities, the justices began leaning forward in their seats, not out of agreement, but out of engagement. Pens paused. Pages stopped turning. And then Justice Kagan leaned forward, her voice controlled but edged with skepticism. "Counselor," she said, "if this court accepts your framework, what stops every local service from running straight into federal court? Police budgets, fire departments, public housing. Aren't you asking us to open a door that never closes?" The room stiffened. Crockett didn't flinch. She looked directly at the bench and answered with a calm tone that carried a sharp undertone of challenge. "Respectfully, Justice Kagan, that fear assumes this argument is reckless. It isn't. What's reckless is pretending education is just another line item when it's the foundation that makes every other right possible." A few murmurs moved through the audience section. Crockett leaned slightly closer to the microphone. "If a child cannot read, cannot reason, cannot participate, then equal protection becomes a slogan instead of a guarantee." She didn't stop there. "This court doesn't need to open floodgates," she continued. "It needs a filter, and I'm giving you one." Then she laid it out with precision. First, the disparity must be extreme and proven, not hypothetical. Second, it must directly block access to the basic tools of citizenship. Third, the state must have failed to fix the harm despite having the power to do so. Her voice tightened, just enough to signal pressure. That is not policy making. That is constitutional enforcement. Behind the bench, a clerk leaned in and whispered urgently to a justice, eyes locked on Crockett. Another justice slowly lifted their pen and began writing again, faster this time. The tension in the room thickened, no longer academic, no longer distant. Crockett pressed harder. Let's be honest, she said. The slippery slope argument is often used as a shield to avoid uncomfortable truths. It sounds cautious. It sounds responsible. But what it really does is protect systems that already failed children. She paused, letting the silence stretch. This court doesn't lose authority by protecting equal opportunity. It loses credibility when it refuses to act while knowing the harm is real. A few heads in the gallery shifted. Someone in the press row stopped typing. Crockett straightened her posture. You asked what stops this from spreading. The Constitution does, your own precedents do, and this framework does. By the time she finished, the courtroom felt tighter, sharper, more focused. Immediately, a justice leaned in, voice sharper, carrying the weight of institutional authority. Counselor, your theory puts federal judges above state governments, he said. Education has always belonged to the states. Are you asking this court to override local control and rewrite how states govern themselves? The question wasn't neutral. It was accusatory. The air in the courtroom tightened. A few observers shifted in their seats. This wasn't just about policy anymore. It was about power. Who gets to decide and who gets overridden? Crockett held her ground, eyes steady, posture unchanged. With respect, she replied, this isn't about taking power from states. It's about stopping states from using autonomy as a cover for constitutional failure. Before she could finish, the justice cut in. So, you admit federal courts would become referees of local education systems? The interruption was abrupt, almost dismissive. Crockett stopped speaking mid-sentence. For a brief moment, the room froze. Then she nodded once, slowly, letting the silence do the work. When she resumed, her voice was firmer, clearer, stronger than before. No, Justice. What I'm saying is, this court already plays that role when fundamental rights are threatened. You intervene when voting rights are suppressed. You intervene when equal protection is violated. Education is not exempt simply because it's inconvenient. A ripple of tension moved through the audience. Autonomy and equality are not enemies, Crockett said. They were designed to coexist. She cited past rulings where the court protected state authority while still enforcing constitutional limits. Federalism does not mean freedom to discriminate. It does not mean freedom to abandon children. It means shared responsibility within constitutional boundaries. The justice leaned back slightly, lips pressed together. A clerk behind the bench stopped whispering and stared forward. Crockett didn't slow down. When state systems produce extreme, proven inequality, this court does not become a policymaker by acting. It becomes a guardian of the Constitution. When she paused, no one spoke. Heads remained still. Pens hovered above notepads. Then Crockett shifted gears, and the temperature in the room changed instantly. She stopped speaking in abstract principles and went straight to numbers. This is not theory, she said. This is measurable harm. She cited long-term funding studies tracking school districts over decades, showing how chronic underfunding translated into lower graduation rates, reduced literacy levels, and permanent income gaps. Then, she pulled the court back to its own history. Brown versus Board of Education didn't just reject segregation because it looked unfair, she said. It rejected it because the evidence proved that inequality in education creates inequality in opportunity. That principle didn't expire. It evolved. The words landed hard. A few justices glanced down at the documents in front of them, cross-checking figures. This was no longer a philosophical argument. It was a data-backed confrontation. One justice cut in sharply. Counselor, give us something concrete. How big does a funding gap have to be before this becomes a constitutional problem? 10%? 20%? Where is the line? The challenge was direct, almost demanding. Crockett didn't dodge it. When a district lacks the resources to provide basic instructional materials, qualified teachers, and safe learning conditions, not luxuries, basics, And that gap persists year after year. The line has already been crossed, she said. Then she got specific. For example, when per-student funding drops so low that class sizes double, core programs are eliminated, and students fall multiple grade levels behind statewide benchmarks, that is no longer budget variation. That is constitutional injury. She leaned in slightly. At that point, the opportunity gap becomes a rights gap. Her voice wasn't emotional, but it carried weight. Children are not statistics, but the statistics show us exactly where the system is breaking. The room felt different now. The legal distance that usually protects judges from the human impact was shrinking. Reporters stopped scrolling on their laptops. A clerk behind the bench slowly lowered his pen, eyes fixed forward. Crockett kept pressing. This court has never required perfect equality. It has required meaningful access. And when access disappears, so does equal protection. Chief Justice Roberts finally leaned forward. Until now, he had mostly listened, watching the exchanges with measured restraint. But when he spoke, the room tightened instantly. "Representative Crockett," he said, voice calm but heavy with authority, "your argument asks this court to decide what counts as adequate education. That sounds dangerously close to policymaking. Are you asking judges to replace legislators?" The question wasn't aggressive. It was colder than that. Institutional, surgical, designed to expose the deepest risk in her entire framework. The digital timer near the podium blinked. Less than 2 minutes remained. Several attorneys in the gallery glanced at the clock, expecting Crockett to rush, to compress her answer, to stumble under time pressure. She did the opposite. Crockett slowed down. She took a breath, adjusted her papers without looking away from the bench, and spoke deliberately. "Mr. Chief Justice, with respect, this court is not being asked to design schools. It is being asked to define the constitutional floor below which no child should be allowed to fall." Her voice was steady, controlled, and intentional. "Legislators decide policy ceilings. You decide constitutional minimums. That division of responsibility is not new. It is the structure this court has followed for generations." Roberts raised an eyebrow slightly. Crockett continued, tightening her argument. "When this court enforces voting rights, it doesn't write election laws. When it enforces free speech, it doesn't manage newsrooms. It draws boundaries. Education is no different." She paused again, letting the silence build. "The Constitution does not demand perfection. It demands protection. And when extreme funding disparities deny children the tools to participate as citizens, that protection is no longer theoretical. It is urgent." The timer flashed again. 30 seconds. Crockett didn't speed up. She leaned closer to the microphone. "Judicial restraint does not mean judicial silence. It means acting narrowly, carefully, and faithfully when constitutional guarantees are threatened." Her eyes stayed locked on Roberts. This framework does exactly that. It respects legislative authority while refusing to abandon equal protection. When she finished, no one moved. Roberts didn't speak immediately. No justice reached for a follow-up question. The silence stretched, thick and unmistakable. Crockett stepped back from the microphone. There was no applause, no reaction at all. And somehow, that was louder than any noise could have been. The courtroom didn't move. The usual shuffle of papers, the quiet coughs, the soft murmurs from the gallery, all of it disappeared. It felt as if the room itself was holding its breath. Crockett remained standing for a second longer than necessary, hands still, posture calm, eyes forward, then returned to her seat without looking back. The argument was over, but the tension hadn't released. It had thickened. Along the benches reserved for attorneys, several lawyers froze mid-note. Pens hovered above legal pads, suspended in the air. One attorney slowly lowered his hand, staring straight ahead, no longer pretending to review case files. In the press section, keyboards went silent. A reporter who had been typing non-stop throughout the morning paused with fingers resting on the keys, eyes fixed on the bench. Even seasoned Supreme Court correspondents, trained to stay detached, felt the shift. This wasn't just another oral argument. Something different had happened, and everyone knew it. On the bench, a few justices exchanged brief glances. Not smiles, not agreement. Something more serious. Recognition. Clerks behind them stopped whispering. The low hum of side conversations vanished. For a moment, it didn't feel like a courtroom. It felt like the aftermath of impact, the quiet that comes right after something heavy hits the ground. No one wanted to be the first to break it. Chief Justice Roberts was the one who finally broke the silence. He didn't move to the next attorney. He didn't glance at the clock. Instead, he leaned forward, resting both hands on the bench. That alone sent a ripple through the room. "Representative Crockett," he said slowly, "before we proceed, I want to acknowledge something." A few reporters exchanged quick looks. This was not standard procedure. Crockett lifted her head, visibly surprised but composed. Roberts continued, his voice steady but unusually personal. "In my years on this court, I have rarely seen an argument that connects constitutional doctrine, precedent, and real-world impact with this level of clarity." The words landed hard. A quiet gasp spread through the press row. Several journalists immediately reached for their keyboards, then hesitated, realizing they were watching something rare unfold in real time. Roberts didn't stop there. "Your ability to anticipate institutional concerns while maintaining a coherent constitutional framework reflects the kind of advocacy that strengthens this court's work," he said. This wasn't polite courtesy. It was professional recognition, the kind that almost never happens publicly. In the corner of the bench, Justice Sotomayor gave a subtle nod, brief but unmistakable. Another justice adjusted his glasses and leaned back, eyes fixed on Crockett, studying her with renewed attention. Across the gallery, whispers began to move, fast and urgent. People weren't just reacting emotionally anymore. They were realizing this moment would travel far beyond the courtroom. Roberts finished with a line that froze the room again. "Advocacy of this caliber elevates the legal profession. It reminds us that strong arguments are built on principle, not partisanship." For a second, no one breathed. Then, the press section erupted into quiet chaos. Fingers flew across keyboards. Phones slipped out of pockets under desks. One reporter whispered to another, "This is going everywhere." Crockett stood slowly. "Thank you, Mr. Chief Justice," she said. "It is an honor to present before this court." Her voice was calm, but the weight of the moment was unmistakable. Then she added something that shifted the moment away from herself. "Whatever the outcome of this case, I respect the court's role in weighing these issues carefully and independently." It wasn't performance humility. It was deliberate restraint, and it sent a clear message. This wasn't about personal victory. The questioning didn't stop. A justice on the opposite side of the bench leaned forward and tried a new angle. "Counselor, under your framework, what prevents states from technically meeting the minimum standard while still designing systems that quietly disadvantage certain communities?" The question was sharp, almost skeptical. Crockett nodded once. "That's exactly why the test focuses on outcomes, not appearances," she said. "Paper compliance doesn't satisfy equal protection. If the results show systemic harm, the Constitution doesn't look the other way." The justice opened his mouth to interrupt, but Crockett continued smoothly. "You can't hide inequality behind paperwork." Another justice attempted to narrow her argument with a hypothetical. "What if a state claims budget emergencies make full compliance impossible?" Crockett answered without hesitation. "Financial difficulty does not erase constitutional duty," she said. "History makes that clear. Rights don't pause during budget cycles." A few pens moved faster across notepads. The back and forth grew tighter, more technical, more intense. And through it all, Crockett never rushed, never lost control, never shifted into defense mode. When the clerk finally signaled that her time had fully expired, Crockett closed her folder slowly and stepped back from the podium. There was no gesture of triumph, no dramatic exit, just a quiet walk back to her seat. Within hours, clips of Crockett's exchange with the justices were spreading across legal forums, group chats, and academic networks. Law schools began sharing the footage with captions that didn't mention politics at all. They called it textbook advocacy. Professors paused lectures to replay specific moments, freezing frames where Crockett dismantled objections line by line. One constitutional law professor told his class, "This is what preparation looks like. This is what control looks like." Another described it as the cleanest example of structured argumentation he had seen in years. Students weren't watching it as entertainment. They were studying it. Then the professional world followed. Large firms added the clip to internal training libraries. Senior partners sent emails to junior associates saying, "Watch this, learn this." Bar associations referenced the argument in newsletters and continuing education sessions. Panels formed around one central question. How did one advocate manage to command respect across ideological lines without turning the courtroom into a battlefield? The tone wasn't praise for Crockett alone. It was admiration for the discipline behind the performance. Meanwhile, political commentators tried to hijack the moment. Some attempted to frame it as partisan theater. Others tried to reduce it to a headline-friendly clash. But the legal community pushed back hard. Lawyers, judges, and professors flooded discussions with the same response. This wasn't politics. This was craft. That resistance changed the narrative. The story stopped being about who won the case and became about how advocacy should be done. The clip wasn't trending because of outrage. It was trending because of respect. And that made it different from almost everything else dominating the news cycle. By the end of the week, it was clear the courtroom moment had turned into something bigger. Not a viral scandal, but a professional benchmark. Months later, when the court finally released its decision, the legal world read it with unusual attention. The justices disagreed on outcomes, as expected. But buried inside the majority opinion were familiar phrases, language that echoed Crockett's framework. Concepts she had introduced during oral argument appeared again, refined but recognizable. Chief Justice Roberts included a rare acknowledgement, noting that the court had benefited from the structured analysis presented at argument. It wasn't a victory declaration. It was something quieter. Confirmation that her reasoning had shaped the discussion inside the building. Behind the scenes, clerks later shared, carefully and without revealing private deliberations, that Crockett's framework had become a reference point during internal debates. Even justices who didn't fully agree with her conclusions used her structure to test their own reasoning. That influence mattered more than headlines. It meant her argument didn't fade when the microphones turned off. The impact kept growing. Law schools formally integrated the exchange into curriculum modules. Training programs were launched under titles like Excellence in Constitutional Advocacy. Crockett was invited to speak, not as a political figure, but as a model of professional discipline. The case itself would be debated for years, but the argument had already secured its place. It outlived the verdict. It became part of how future lawyers would be trained to think, speak, and perform under pressure. If you want to keep following the courtroom moments that reshape history, the ones that don't rely on noise but on impact, make sure to subscribe and stay connected, because the next defining moment is always closer than it seems.